Well, welcome, friends. It's been a little while. My name is Carolyn Lee, principal and founder of Carolyn Lee, Pllc, a U.S. investment immigration law firm dedicated to helping clients build their futures with investment immigration. And of course, you are here with us in investment immigration conversations. And I am here with my dear friend and truly an EB-5 luminary, Suzanne Lazicki. Suzanne, hello.
Thanks, Carolyn.
Thank you so much. You've, through your in-depth analysis, observations, sort of this neutral, like, let's just kind of unpack this stuff and try to understand what's happening, lens in all things EB-5. Rightfully so, you have built a following that is not only devoted to you, but really relies on you for news and analysis in EB-5. So thank you.
Well, you are the pioneer in this area.
Oh my gosh, not even, but we'll just leave it at that. Well, we have to share with you the breaking news, right? I mean, this literally just hit all of our email inboxes. Missive from USCIS guidance, EB-5 reform and integrity act of 2022. So we must read this to you, and then we'll move on to the topic of the day, which is all about EB-5 numbers and the Visa Bulletin, okay? Because of course we're starting the new fiscal year. So, okay, so I'm reading USCIS guidance. On October 11 today, we issued additional guidance on our interpretation of changes to the EB-5 Immigrant Investor Program in the Immigration and Nationality Act, INA, made by the EB-5 Reform and Integrity Act of 2022, RIA, as we affectionately call her. This guidance clarifies the required investment timeframe for EB-5 investors who file Form I-526, Immigrant Petition by Standalone Investor, or Form I-526E, Immigrant Petition by Regional Center Investor, on or after the enactment of the RIA, March 15, 2022, as outlined in the RIA. This guidance also clarifies our interpretation of INA 203B5M, good faith investor provisions, regarding investors who are associated with a terminated regional center. Background. March 15, President Biden signed the RIA as part of the Consolidated Appropriations Act, among other things. RIA changed the whole framework. I'm going to skip right down to the key points. Key points. Because these changes made by the RIA, investors filing petitions for classification after enactment of the RIA no longer need to sustain their investment throughout their conditional residence, which may be many years in the future and dependent on factors outside the investor's control, such as visa availability. So this is big. This changes the definition of the sustainment period for post-RIA investors. Instead, I'm reading, the INA now requires only that the investment must be expected to remain invested for at least 2 years, provided job creation requirements have been met. Although the statute does not explicitly specify when the 2-year period under the INA 203B5A1 begins, we interpret the start date as the date the requisite amount of qualifying investment is made, and believe this interpretation is consistent with the statutory language, 2 years from the time of investment. In other words, we will use the date the investment was contributed to the new commercial enterprise and place that risk in accordance with applicable requirements, including being made available to the job creating entity. If invested more than 2 years before filing the I-526 or 526E petition, the investment should still remain at the time the 526 or 526E is properly filed, so we can appropriately evaluate eligibility. So much there. This is the topic. That paragraph there, topic of an entire webcast in and of itself. Before enactment of the RIA, the termination of a regional center would have been considered a material change to eligibility for investors who had not yet obtained conditional permanent status, and consequently would likely have resulted in a denial or revocation of associated investor petitions. The RIA added a new provision at INA 203B5M, as in Mary, that permits good faith investors associated with terminated regional centers to retain eligibility in certain circumstances. Because the statute does not explicitly specify whether it applies only to post-RIA investors or also to pre-RIA investors, we are providing guidance on this. Number one, we interpret INA 203B5M to apply to pre-RIA investors. Yes, associated with a terminated regional center or debarred new commercial enterprise or job creating entity. However, rather than strictly applying the notification timeframes in that subparagraph, we will extend the deadline for pre-RIA investors to respond to regional center termination notification until the agency adjudicates their Form I-526 petition. If needed, we may issue a request for evidence or notice of intent to deny for the investor to establish continued eligibility. That's nice. Second bullet point, we may use the procedural flexibilities provided under subparagraph M to extend the response deadline of 180 days for notices of continued eligibility. The extension will decrease the likelihood of operational burdens and expand the intent of the statute to permit good faith investors of terminated regional centers to retain their eligibility. Also nice. When a regional center is terminated for purely administrative noncompliance, we may determine that the termination would generally not adversely affect a pre-RIA investor's basic eligibility under 203B5, including the ability to continue to claim indirect jobs, because their investment and resulting job creation would likely remain undisturbed. Fourth bullet point, we may choose not to extend applicable response deadlines when a regional center is terminated for substantive reasons that may affect continued eligibility of their associated investors. That's it. Wow.
You have your next 3 webinars right there.
And I was thinking that my next 3 would be on numbers because there's so much there. So there's a lot here. This is very, very, very important stuff. And we will all be talking about this in the days and weeks and months and years indeed to come. And maybe Suzanne, we can talk about this on another occasion as well. Whew. Suzanne, do you want to share any observation about this before we launch our numbers talk?
Well, this is very important. We've been waiting for it for 1.5 years. And the things that I think we're particularly going to be talking about, what it says about the sustainment period, and then also the treatment of investors in a terminated regional center, which I expect we're going to be seeing quite a bit of that happening. And I hope in your next webinar, you talk about what you think USCIS thinks the differences between administrative reasons and substantive reasons for termination, because that's going to affect the lives of a lot of people.
Oh my, yes, there's so much here. I honestly don't even know where to begin. Okay, so let's not. And instead, let's talk about what we're here to talk about today. Okay, so what we're going to do, I don't like to have presentations and PowerPoints in talks like this because I've got fabulous guests like Suzanne, and we just like to talk, to converse. But this is technical, and Suzanne and I truly want to do our best to impart understanding in this very technical and very, very, very important area of EB-5. So I am going to open a little presentation here. And Suzanne is going to chime in and sort of elucidate and challenge from time to time some of the points in this, okay? Which really I'm kind of looking forward to. Just be nice, be gentle with me. All right, so let's do this. I'm gonna have to first figure out how to get this in like presentation mode, which I like to do. All right, so from beginning? Okay. Is the whole thing showing? Looks a little odd on my screen. Okay. Okay, cool. All right, so we're going to talk EB-5 by numbers and not by the numbers, by numbers. And what I mean here is when we talk the numbers in immigration and in EB-5, it is its own language. There's a whole framework. And so we're going to try to, again, impart a sense of that today. And by no means are we going to cover everything. So I'm going to disclaim everything, including timeframes, estimates, statistics, future gazing. Okay, so this is conversation. I do like to start when we have difficult topics, when I'm trying to understand something, I like to start at the bottom. I like to start with the most fundamental elements. And here we are. So this is the foundational statutory framework for the numbers. The Immigration Nationality Act, the INA, it sets limits. That concept of limits is central to immigrant visa numbers, to the green card system. And what does that mean? It means we have quotas. It means we have a set defined number of visas that can be issued every year. So the concept of limits and allocation numbers, this is fundamental to the framework. The first pillar is INA Section 201D, which sets the worldwide limit, the number of employment-based immigrants. It sets it for family-based as well. We're focused on employment-based because EB-5 is nested in the employment-based side of the numbers. So 201D sets the worldwide limit for employment-based numbers, and that number is 140,000 in a normal year. The second pillar is the per country limit statute, which is a 202A2, and it sets the per country max, again, the limit at 7% of the worldwide limit in 201. So the language here is we're talking about the total number of immigrant visas that can be made available to natives of any single state under subsections A or B of 203, which we're going to get to in a moment, that's our third pillar, may not exceed 7% of the total number of such visas made available under such subsection in that fiscal year. So you see walls here everywhere. There's a wall around the fiscal year. There's a wall around the worldwide limit. There's a wall around per country cap. There's a wall around the specific section in the employment-based preference categories. Next and final pillar here is Section 203B that's just referenced right above in the per country cap statute. This is where the allocation of the 140,000 gets made along the employment-based preference categories. Okay, so this is the language in the statute. Aliens subject to worldwide level in 201D, i.e. 140,000, shall be allotted visas as follows. Now we are in 203B5. Now we're in EB-5. Okay, so this is our universe, and the first thing it says is that this number, our EB-5 number, is not going to exceed, again, a limit is not going to exceed 7.1% of the worldwide level of employment-based visas. So it's not going to exceed 7.1% of 140,000. Okay, so that number, as we're going to see in a moment, is about 9,940. Now, this part is new. In 203B5 now, we have a new section on the reserved visas. This is another term for the set-asides. And this is where we have the 20% of the 203B5 allocation set aside for rural, 10% for high unemployment, 2% for infrastructure. Now, this next bit is important. This is about the mechanics of how these numbers will get carried over if there is a year where they are not all used. We're still talking about the set-asides. The unused set-asides stay in their respective categories in the next fiscal year if they're not all used in their native fiscal year. And then if they're not all used in the carryover year, then they will be made available to the unreserved, okay, to the general pool that's not set aside. Okay, that's not reserved, also known as unreserved. Okay. All right. So this is my attempt, and this is where Suzanne may take, go, oh, well, I don't agree with that or what have you.
I actually checked my Excel, and I found the place where our numbers are different, but the overall presentation is correct. It's just a FY 2022 rollover. So since the overall presentation is good, let's take a look at it.
Wonderful. Well, that is a relief and high praise, I might add. Okay, so this is my attempt to lay out the numbers as we have them. There is a wealth of information, of data that's out there, but it takes a lot of time to look for them and collect them. And so this is an effort to distill the high level, the important numbers, okay? Projecting demand. So here we are, and all the way on the left, we've got these categories that we just talked about. We've got the annual limit, we've got the EB-5 limit, we've got the unreserved, okay, the general pool, and we've got the set-asides at 20, 10, and 2. So this is the normal 140,000 plus under the statute, whatever is unused on the family sponsored side will roll in here. So the 7.1% EB-5 is 9,940. So that gives us, if we do the 32% here at 20, 10, and 2, the remaining is that 6,758 approximately. There's a tiny bit of rounding that's a part of this. So in fiscal 2022, this is year 1 of RIA, because RIA passed March 2022. We actually had a gigundous annual limit in EB-5 because there were a ton of unused family sponsored from the consular closures still recovering from COVID. So the worldwide annual limit for employment based was actually 281,507. Wow. So then you just run the proportions down these categories, and these are the numbers we had in 2022. Approximately 20,000, double in EB-5, and then split 13,600 in unreserved, about 4,000 in the rural, about 2,000 in high unemployment, about 400 in infrastructure. All told, 6,394, give or take, in set-asides alone. Fiscal 2023, that's the year that we just closed out, okay? At September 30, 2023, ended fiscal 2023. We still had a lot. We had 197,091 in employment-based. So that meant, just running the proportions again, we had about 14,000 in EB-5. It's about 5,000 more than usual, or 4,000 plus. In unreserved, that's 9,515. So that's almost our annual limit, okay, in the unreserved alone. And then in the set-asides, applying this carryover mechanic, we had 5,985 in rural, 2,992 in high unemployment, 598 in infrastructure, for a total of 9,575 in the set-asides alone. Again, this number is like our normal annual limit in all of EB-5.
And Carolyn, here's where I put in the correction just for the numbers in that you have highlighted in red there.
Okay.
You put those the normal year annual limit, but 2023 was higher. So if you did the 197 or the 13,993, it's a little higher than that for the total for the reserve.
Ah, so I see what you're saying.
The news is even better than you had calculated, because there are even more visas that are potentially going to roll over.
And this is the thing. In doing this, I kept finding more numbers. So this very exercise of studying this, I think, is important, and hopefully will yield fruit in our advocacy and communications with the agency, particularly the State Department, that's vested with the authority to do this, to count and to allocate.
Yeah, and I think it's so good that you did this chart, because it really highlights sort of the contrast between the rules that you just went over, and then here are all the ways you can have exceptions to the rule. Like you just told us, here's the annual limit on EB visas. It's 140,000, but thanks to the rollover family-based in real life, it can be a lot higher than that. In principle, EB-5 gets 7.1% of total EB visas. The fact for the past few years has been higher than that because of the impact of rollover visas. And then if we wanted to drill down into who gets these visas, in principle, there's the limit that you talked about, one country, 7.1%. In fact, in fiscal year 23, China got way more than that because it's not limited to the, it gets at 7.1%, plus it can take advantage of otherwise unused visas. And in the past year, Vietnam should have gotten more than its 7.1% because the 7.1% just applies to people who have excess demand across family-based and employment-based. And even though Vietnam has a lot of EB-5, it doesn't have a lot in other categories. So it could potentially have gotten more than the 7.1%. So there's a lot of confusing nuances for people to keep in mind.
Oh my gosh, so good. That's exactly right. And that's why people like bang their heads against this, because it's the exceptions almost swallow the rule. You cannot unpack this just knowing what the rules are, what the statute says. So anyway, I'm going to stop here and maybe we'll come back to it, but this is it. This is the work, roughly. All right. So let's use this as an illustration of the availability of the data. So this is taken from USCIS's data bank. And USCIS publishes quarterly usage data reflecting the number of applications in, adjudicated, pending, denied, etc. And so now this is very, very limited, okay? As Suzanne pointed out in our discussion, quick discussion before going live. This is a slice of the story, okay? What slice is this telling us? This is revealing the number of approved cases, 526 petitions, awaiting visa availability, meaning they're not current, they're awaiting visa availability as of June 2023. So they were not current in June 2023, but they were approved, these petitions. And so we can see this number is not crazy. It's 21,000, right? It's 18,880 from China, and it's 2,157 from India. But it is not, this is by no means the entirety of the backlog, because number one, it only covers, it's only showing us China and India here. And it's only showing us the approved, it's exactly what it's telling us, approved, not pending, approved cases awaiting visa availability. So we don't know how many were available to take advantage of visa availability in June 2023. Okay. All right. Now this is, so those numbers were about pre-RIA demand. This is a window into post-RIA demand and usage, again, using the same report from USCIS. So this is showing us the number of 526 e-petitions filed third quarter 2023, ending June 30, and it's 649. We've all seen that number much, much higher. And year to date, fiscal 2023, 1,558. Modest, which I would say is good. We don't know how many, we don't know how many years, but these are modest numbers relative to what we've seen. Now the Visa Bulletin. So this is really just sort of a primer, right? You know, just kind of want to lay the framework and show you where to go. The Visa Bulletin is published every month, and it shows us what, where the State Department is in its job of allocating the visas. That's its job, is to look at those annual limits and to budget them quarterly and to allocate them based on the demand that they're getting from posts, consular posts worldwide, and from USCIS, processing adjustment of status applications. So you go right here, and it looks like this. And you usually see two areas here. There's going to be the current, and then there's the upcoming for the following month if it's out. So by the middle of a month, the State Department will have published the Visa Bulletin for the following month, as it has right here. We've got the November Bulletin out. And when you open and scroll, you're looking at the final action. You're starting by looking at the final action dates for employment-based. It's going to have family-sponsored first, scroll, and then you get the employment-based. And this is chart A. This is, this shows where the State Department is in terms of being able to actually issue numbers this month in November 2023. This is a screenshot from November 2023. There's also a chart B, which is subject for a whole other discussion, very, very important, more important than ever, especially in EB-5, with current adjustment of status filings brought under the RIA. So we really need to talk about that on another occasion. This is just a screenshot of like I track the Visa Bulletin movements. And I just did a little screenshot here of just this past fiscal year from October 2022 to where we are today, November 2023. And I've highlighted in green the months where chart B was open for USCIS and adjustment of status filings. This is, I guess, a teaser, if you will, a bit, because this is really important for us now to know when chart B is open with USCIS, not only for us to know when we can file adjustment of status applications, not so much for the post-RIA cases, because you see they're current, but so they can file adjustments now, but for the pre-RIA cases, because those cases, we're going to need to be looking for the cutoff dates. Okay, and this is also important now to track Child Status Protection Act affordability because of the service's recent change on how it will determine visa availability now using chart B. So that, again, is another very important topic. Visa Bulletin vocab, so much out here. Yeah, I'm just going to start with these because you see these codes in the Visa Bulletin. What do they mean? C5 means direct non-TEA. Very few, but there are some indeed. T5, direct TEA. These are standalone cases, right? I5, RC TEA. So that's the vast majority of cases. R5, RC, regional center-based non-TEA, right? Very few. More to come, we know this, because the set-asides are coded. Visa Bulletin, I wrote a little article about this, kind of unpacking it some time ago. Current means it's the expression of the date that is the cutoff date on or after which is not yet qualifying for visa issuance. So if an applicant's priority date is earlier than the cutoff date, then or the final action date specifically under Chart A, then a visa may be issued. There's visa availability as defined by the State Department. And the final action date, that's the date that we used to call it the cutoff date, and but now it's the final action date. Dates for filing visa applications, this is the Chart B cutoff date. So if the priority date is earlier than the Chart B dates for filing cutoff date, then that applicant is eligible to file for adjustment of status application, though not yet to be approved, because for that, the applicant's priority date has to be current under Chart A. Priority date is the date that USCIS receives the immigrant visa petition, the I-526 for the 526E. Unavailable. Sometimes when there's oversubscription, when there are no visas that may be issued in a particular month, because, for example, there's a lapse in the statute or there's overusage. Sometimes happens toward the end of the fiscal year, then the State Department will publish unavailability for that visa category, unavailable or U. Oops. Resources, first of all, Suzanne's blog, naturally, encyclopedic, please go there. For government resources, citizenship, USCIS data, as we referred to just now, right there. This is quite the gem. Suzanne, have you seen this?
Yes, I was going to point that out to people on this webinar as well. This is very useful and it's very regularly updated. Someone is really working hard on it.
This is fantastic. You can learn a lot, glean a lot of useful information. Go there.
Including quite a few Q&As on the October 2023 Visa Bulletin specifically.
Yes, exactly. It's like somebody heard, right? You know, somebody heard, we need information, we need to know what's going on. And many of the answers are there and very much appreciated. U.S. Department of State Immigrant Visa Statistics, okay, they are the number managers. So, and lots and lots of numbers, sliced and diced in different ways, go here. September 2023 Visa Bulletin is very insightful. The end of the fiscal year Visa Bulletin will give us more insights into the usage over the course of that fiscal year. And this is where we learn how many numbers in employment base there were in fiscal 2023, because that's reported out at the end of the fiscal year there.
I would also note on the Visa Bulletin, people should make sure to not only look at Chart A and Chart B, but scroll all the way to the bottom just to see if there are any notes, because sometimes there are relevant notes that will say something about what Department of State expects EB-5 even to do in the coming months or other useful information. So always scroll down and take a look.
Very true. So very true. Suzanne, I mean, if you would blog about, you know, what the good stuff, the nuggets to be found scrolling beyond Chart B, that it would be tremendous. I mean, honestly, I think all of us, we just sort of focus on the dates in those 4 magic lines in both charts, and then we think we're done. But truly, no, there is a lot more, especially at key times in the year. Just some of the articles, folks registering for the webinar will get the presentation. And so there's just a lot of background stuff, stuff I've written over time. So do check those out.
Carolyn, there are a couple other resources that I was going to mention to people that I could put in the chat, but I'm interested to see if you have any insight on them. People are always asking me, and I don't know what information there is about what are the timeframes for NBC, what are the timeframes for the consulates. And the 2 sources that I do know about are on the Department of State website. One is a page called NBC Timeframes and another Global Visa Wait Times. I don't know if you have an opinion on those sources as far as something for whether that's relevant for immigrant visa applicants to look at. Yeah,
I mean, I must say I don't use, I mean, the non-immigrant one I do. I mean, just because you sort of need something, even if you know that, you know, they can't possibly be very, very precise. So I do refer to those. But really, I like to look at the immigrant visa issuances by post, the monthly data. Yeah. Because, you know, that doesn't tell you, that doesn't answer the eternal question of how long and how long must we wait, that kind of thing. But it does give a very good flavor for the pace of things. You know, I was just very impressed, quite honestly, to see in August, almost 1,000 EB-5 visas issued out of Guangzhou. Because when you see the November movement, or rather the October, it's the same in November, the fiscal year did not kick off with a bang for Chinese investors in the backlog. It did for Indian investors, huge leap in final action dates. But for Chinese investors, it was a month. So one wonders what's going on there. And so, you investigate, you look at the data. And I was very surprised to see that in August, there were so many visas issued out of Guangzhou. So they are trying to churn them out. So that is a question I think we want to look a little further into.
Right. Yeah. Because I always put anything that's in Excel into pivot tables and take a look. I do follow those monthly visa issuance reports very closely. And it is interesting, again, to see how the reality departs from the theory so often. For example, the theory, and they reiterated in the October Visa Bulletin that they were going to stick to this, is trying to divide up the annual number of visas into more even quarterly allocations. So in each of the first 3 quarters, you don't give away more than 27% of the visas available. And I don't know, maybe they're doing that across all visa categories, but if you look at just EB-5 specifically, it's really uneven. For example, last year, Mumbai gave a whole bunch of visas to Indians just in the first quarter of the year, whereas Guangzhou didn't really ramp up towards the end of the year. And so it's interesting to see those trends.
Totally, totally. Gosh, I would love to talk to you more. The State Department, I believe, is required under the statute to do that, to do that budgeting.
And the note in the October Visa Bulletin says, yes, we have set the dates in the October Visa Bulletin with a plan to do that budgeting.
Makes sense. Start of the fiscal year. The reason I put Q and AA is we are going to attempt to answer the questions. So let's do it. We've already got some live, and let's just grab those, and we'll start with those, and then we'll look at some of the other questions. All right. So Suzanne, thank you so much for sharing in the chat. We've got.
Yeah, I've just been putting links in the chat as you brought things up that
cool.
I just put the link to it.
Folks, please copy those links, this panel. Okay, so we've got questions in the Q&A. Fantastic. Oh my gosh. Thank you. Just a sweet, kind word.
I would be very happy if you were head of immigration, Carolyn.
No. But you know what? Because having too much authority is just not good, actually. We wouldn't want anyone to have too much. As an Indian national, does it make sense to invest in urban? Should we only be looking for rural investments? Wow. Yeah. I feel like I get this question in some form almost every day. Suzanne, what do you say?
Yeah, I hate to just answer this off the cuff. I'm looking to see if one of my slides could be helpful on it. Let me see. Yeah, as far as making the calculation, if I invest right now, when I get to the visa stage, is there going to be a visa available to me? One thing that we look at is just how many I-526 have been filed across the board so far, and could that possibly lead to a backlog situation in any of the categories? So far as we know, around 2,000 I-526 have been filed since the new law passed. I think we can assume that all those 2,000 I-526 are in a set-aside category of some kind. And so we don't know how they're divided up. AIIA has a FOIA litigation on that I think they're expecting to get a response on maybe in the coming week. So when they get that information, that will be very useful to know. But so let's just think about the scenarios. There are 2,000 I-526. What if they're all for high unemployment? And let's say that those I-526 result in a demand for at least 2 visas. So then we would be thinking, okay, that's 4,000 visas that would be demanded. Are there going to be 4,000 visas there for high unemployment applicants? If they all get to the visa stage this year, there will be. because there are so many rollover visas. Maybe you can look at Carolyn's thing again.
Yeah, exactly. I mean, that's
Well, actually,
exactly
no, not quite this year.
right.
According to my calculation, there'll be a few more. Yeah.
Right. But you can see that's exactly how you do it. You look at the number filed in the set aside category. And now here's important. This is the visa number that can be allocated. There's a bit of crosswalk between USCIS number and this number. USCIS number is going to report petition. It's investor only. So there is a multiplier that we've got to apply to get to crosswalking that USCIS number to this number. We've got to apply, it's the spouse, it's at least one child. So it's like, 3 point something is the typical multiplier. Although I'm very interested to see how that's going to change, because with concurrent adjustment of status filing, we've got lots of students. So that could affect that multiplier, as we will see in due time. So yeah, I mean,
right. But so let's say that the 2,000 people who filed I-526 all reached the visa stage this year, which they won't because of the processing times. But if they did, let's say there are at least 4,000 applicants, and if they were all high unemployment, if they were all rural, then even if they were all rural, there wouldn't be a backlog because there's enough visas this year for rural. If they were all high unemployment, there would be, because there aren't 4,000 visas available for high unemployment. So we want to know what that risk is.
Right. And, and this isn't going to go to answering that question precisely, which of course is what we want the answer to. But this gives you a feeling, it does give you something, I was predicting, with all the qualifiers, that we will start to see cutoffs in 2025, in fiscal 2025. And I think, that feels right. And it looks like we may not see cutoffs in fiscal 2024. But we'll see. It could be close toward the end of fiscal 2024. We could start seeing cutoffs in maybe rural or maybe high unemployment. But in terms of the raw numbers, based on projecting out the usage, it's not awful.
Yeah. Also, as far as predicting how many reserve visas are going to be available year by year, until USCIS starts to move things to the visa stage, we can anticipate that every year will be about double the normal limit in reserved due to this rollover. And another very important bit of information that we got recently, IIUSA leadership met with somebody from Department of State who gave them a nice presentation on how Department of State is handling EB-5 visas. And one thing he said is that in a year, when they're allocating visas, they're going to start by allocating the carryover before allocating visas that are new that year. And that's bad news for unreserved, but good news for reserved, because that policy will maximize how long the reserved visas can carry over.
Share that one more time, because that's important, and I can imagine folks having questions about that. So he said,
so how the carryover works is that visas that go unused and reserved 1 year go to reserved again the following year, and after that they get lost to or they go over to unreserved, and reserved can't use them anymore. And so like looking at fiscal year 2024 right now, they have approved some rural I-526E, we know, so they're going to be issuing some rural visas. So the question has been, which number is going to get less here, the pink number or the red number? If they issue one rural visa, is it going to be this year's allocation that's less, or is it going to be the carryover that's less? If it's the carryover if it's the carryover that's less, that's good for reserve, because reserve only gets to keep that carryover one more year. This year's they get to keep for 2 years, so they have more time to use that number.
That's good. Yeah, because this number, this is the last year that this carryover could stay in rural. If it's not all used up, then it's going to go to the unreserved in 2025. So they're saying that there is an order to how they're going to allocate these numbers, and they're going to start with the carryover first and deplete those.
By the way, Carolyn, one of the comments is please close the next slide view.
Oh, yeah. Okay. So my
people are probably squinting to see the
oh
slide.
Heavens. I would, but I don't know how. So I'll just stop sharing and maybe I can figure it out the next round. Okay, but we have more questions. All right,
but
cool.
I would say overall, based on my slicing and dicing, I think that we have, with the number of carryovers we have and what I guess about demand for rural visas, I think that there's still a chance that India still has availability within high unemployment, but it will be really nice to get the answer to that Freedom of Information Act request and find out how demand has been distributed. And also it's going to be really important at what rate the I-526E get adjudicated and can reach the visa stage, because we have a lot of visas now. We'll have slightly fewer visas next year, slightly fewer visas the year after that. And I don't know what you're hearing, Carolyn. I've heard of some rural and some high unemployment I-526E approvals, but like in the dozens, not in hundreds. I don't know. What are you hearing?
Yeah, I mean, I'm hearing like, so if I'm just doing the math of what it's 100 rural or so, maybe a little less. 100, yeah, that I've heard of. So there's got to be more. And I have heard of a few high unemployment, but that's not many. Yeah.
So what would be your guess as to when people who are filing now, I-526E, or people filed in past year, when do you think it's most likely they'll be reaching the visa stage?
I mean, we are hearing, and I have it on very good information, that there are rurals getting approved from that filed in fiscal 2023. So there will be demand. So unlike 23 and 22, we will definitely see demand for the numbers in fiscal 2024. So the question just is in which set-aside category and the pace. I mean, are we going to use the 6,900 or so set-asides that we have this year? I don't know.
Well, we couldn't possibly, I don't think, because as of June, only fewer than 2,000 I-526E had been filed ever. And unless they had really big families,
right?
But historically, it's once you account for denials and small family sizes and so on, it's more like 2 to 2.5.
Yeah,
as far
and
as
it's approvals, and when they're going to be approved, which is the other big question. So yeah, I would say it doesn't today at the start of the fiscal year, it doesn't look likely that we're going to chomp through those set-asides this year, you know? But again, cutoffs very likely in 2025. And who knows, we may, I mean, toward the end of fiscal 2024, especially in rural, because of the prioritized processing. And a lot turns on what USCIS actually does to give effect to that, and how many.
But again, the supply numbers are nice. So even if tomorrow USCIS approved every single I-526E that's ever been filed,
right?
So far as we know, at least as of June, that was only about 2,000.
Right.
That's not going to make demand for 5,000 rural visas.
Right. Right. So good news, like better than I thought before doing this. All right, so please close the net. Sorry. What are your expectations for I-526 approval? Timelines for post-RIA, barring any retrogression specifically. If post-RIA, 526 will be separate queue or will be behind pre-RIA.
I think we can conclude that it's separate queue, don't you think, Carolyn?
Yeah.
One thing that's certain too is that it almost has to be a separate queue, because not only are the rules different, but it's also a different process. Now it's an I-526E preceded by the I-956F. So USCIS has to approve the I-956F before they can even look at the I-526E. And then once the F is approved, the project review is done. They're only looking at source of funds in the E. So it's really a totally different processing scenario.
It completely is. Oh, there's exactly right. I mean, there's no question really, because also, I mean, let's talk about visa availability processing. This is USCIS's policy of adjudicating cases that have visa availability. So you could have a pre-RIA case that's very old, but under this policy, it will not be adjudicated ahead of cases that are current. And so remember all those C's and the set-asides. So all of those set-asides under that visa availability approach will get primacy in terms of adjudication resources than the RIA cases that are behind the cutoff. So yeah, there definitely is a different process and different queuing. And then in terms of timeline for 526 approval, I mean, there are approvals, right? I mean, but there are a number of the November 2019, the pre-modernization regs cases that remain unadjudicated. So I think we need to look at the data set for the pending numbers and sort of track the movement to try to get a handle on the objective pace of things there.
Yeah, as far as pre-IAA cases, I have very granular data on that, which I put on my blog. As far as the post-RIA, I don't have that detailed insight, but I definitely, anytime that I hear about an I-956F approval or I-526E approvals, I log that and keep that in mind, and it will be very interesting if we can see trends emerge. Right now, it's really hard to say anything, because if there are 2,000 pending, 100 have been approved, you can't make conclusions about what is the processing time from the experience of those 100 that did get adjudicated without thinking about how long all the 1,900 that didn't get attention, what happened to them. But yeah, the fact that we have seen so much activity both on I-956F adjudication and some I-526E makes me think that the E's are not going to be looking at 3 to 4 to 5 year processing times like I-526 did. It's going to happen more quickly than that.
Yeah, I agree. Okay, so India Chart A date is December 2018 and Chart B date is April 2022, unreserved, yes. Does this mean Chart A date will eventually reach April 2022 by 2024 end? What do you think, Suzanne? Chart A movement.
Well, to think about that, I think it's important to just look at the background of what makes things move. The movement is just a function of supply and demand. So in order to think about how's it going to move, I want to look at what's the supply this year, and then what's the demand associated with those dates. And in order to think what's the demand associated to those dates, the demand for visas is a function, or is something that comes out of who filed I-526 at those dates, which is something that we know. When I'm done talking, I'll put a link in the file. Matt Galati got a FOIA request that asked for the number of India I-526 filings by month in 2018 and 2019. So I can add up, and I know that from July 2018 to December 2018, there were 1,500 Indian I-526 filed. And so if you want to, or actually, no, sorry, 773 I-526 filed, which I estimate is going to, if I double that, it's going to be at least 1,500 visas. India has about 1,000 visas available this year in unreserved. And so that tells me that
it's not going to move much.
Yeah, but those numbers that I'm giving you are for all the I-526 filed. And what they're looking at the visa stage is not everybody in the process. The Visa Bulletin can only see who's documentarily qualified at the visa stage. They're not looking at all those people who have I-526 pending. They're not looking at people in the no man's land waiting for their NVC fee letter to arrive. So it's possible that the Visa Bulletin could still move if all those people who are out of the Visa Bulletin view can't make it to be documentarily qualified at the visa stage. In that case, whoever are the few people there who are there can get visas.
I was just thinking that maybe just taking a quick peek. I'm sorry, it's still nested, right? I don't know what to do to make this not do this.
Actually, it's looking good for me.
Oh, is it? Okay, good. Hopefully it is for our audience too. But I mean, just let's take a look here. So this is just in the 12 months fiscal start of it's from October 2022 to where we are today, November 2023. And so here's India. And it stayed, in start of the fiscal year, it stayed in late 2019 for a long time. Then it retrogressed. The reds are retrogression. And it stayed in June 2018 for a while. And then, this is retrogressed again. And then it leaped. Okay, it did have a leap at the start of the fiscal year. But based on what Suzanne just reported, and again, we don't have all the data, but it's, I don't know, doesn't sound like we're going to see a whole lot of advancing in fiscal 2024. Okay, chart B, of course, different story. Yeah. Chart B, there's a lot to say, because the service seems to be quite good at using the device of adjustment to chunk through the numbers, right? And I had that number in one of the slides in fiscal 2022, for example, when we had that deluge of numbers, we had 281,000 as the annual limit rather than the 140,000. USCIS reported that it adjudicated 220,000 adjustments in fiscal 2022. So it is able to really kind of capitalize on the extra numbers. Chart B, availability, adjustment of status. Chart A, more varied, I would say. Consular capacity is not as vast as adjustment.
Yeah, as far as the movement of chart B, I was also listening to WR Immigration's, their webinar on the October Visa Bulletin, and they always ask Charles Oppenheim, who's now working for them, but was formerly at Department of State, to interpret what he sees in there and what's going on behind the scenes. And he did mention that he was surprised by the chart B dates for China and India. And one thing that he mentioned as far as why Department of State might have said said it that way. And let me see, actually, I think I wrote down, it could be State Department's effort to spur USCIS action on pending petitions in order to stimulate demand use visas. And so translated, it's if they set the Chart B date way forward, that opens up the inventory that USCIS can process. And they want USCIS to process more petitions so that they have more to work with. And when they set the Chart B date for India to April 2022, that's literally setting it at the end of the line for unreserved visas. I don't think there's anybody after that. So they're basically just opening it up wide. And with China as well, they moved China Chart B a whole year. By my calculation, that opens up more than 20,000 Chinese who could apply. So one thing that does is stimulate demand. Another thing they mentioned in the WR immigration, they said there had been a bipartisan letter advocating for advancing employment-based Chart B to allow for more filings. And I don't know if you've heard of that. I didn't know about that, but that is, I don't know if they did that as a nice gift to EB-5, but definitely it is very nice that even if these people in Chart B couldn't possibly make it to Chart A by the end of the year, which is how they're technically supposed to set it, it is very nice that all those people who are in the US can take advantage of I-485.
Absolutely. Yeah, I mean, you know, I think we've got to use these numbers, excess numbers, get them out of the system. It's going to have a healthier ecosystem that way, and adjustment is that's the way to go. That is the way to go. As I think I've written about and you've observed. So just keep our fingers crossed that it'll stay that way. I think it will. I don't see anything kind of lining the other way. You know?
But to respond to that question, although it is the general principle, as I understand, the Department of State sets Chart B to where they anticipate Chart A could be a year from now, I would say it's impossible for India EB-5 and China EB-5 to reach that date a year from now, unless just a huge number of people have dropped out who started the process. Just looking at I-526 filings, we would have had to lose like 40, 50% of those people in order for that to be achievable. Or the other way that something can happen is if USCIS just sits on its hands and doesn't adjudicate petitions. So Department of State has to give out to whoever they have. But from a USCIS has been picking up the pace of legacy I-526 as well as adjudicating new ones. So I think that they are working hard to get more demand to the visa stage. And when more demand gets to the visa stage, then the Visa Bulletin traffic signal says slow down. And we see things moving more slowly.
Yep. Agree with all of that. All right, next question. What is the expected time frame for 526E post-RIA approvals for India and China applicants in both urban and rural TEAs? Approval timeframes. Well, yeah. Suzanne, what are your thoughts on that?
Yeah, I think it's too early to say what's a standard or what's expected. We know based on the experience of ones that have been approved that it's possible to get approved in less than a year. What we don't know yet is how long it's possible to wait without getting approved. And if I were an investor, I would look at whether there's been an I-526F approval in the project I'm looking at, because if there has been an F approval, then the I-526Es we know are in the queue where they could get assigned at that point. And my guess is that USCIS wouldn't want to leave those too long because they're forced to give deference to the F adjudication, and they won't want to give deference to the F if it's been waiting a long time.
you
But
know.
I'm interested to hear your insight on that, Carolyn.
Well, I think you're right. I think it's just too early, you know, when we can kind of count how many approvals we're hearing about. It's just, this is the point you made earlier. We don't have enough data yet. But I think we will. We will this year. We will definitely have a sense of the pace for approvals.
My guess also is that the Immigration Service is getting a lot of pressure to approve these E's so that the visas don't go to waste. Do you think that's plausible?
I'm sure
that would affect their workflow?
I'm sure there's all kinds of pressure, including, you know, I'd like to think, you know, sort of something akin to moral pressure, just the sense that we don't want these numbers to be wasted. And yet there are competing concerns too. You know, I can't imagine that an examiner is going to want to think that, oh, you know, take shortcuts or feel that way. These cases are going to have to be vetted to every single examiner's satisfaction. And sometimes we complain about this, and rightfully so. But I don't know how it's going to respond. I mean, we can't sort of, as frustrated as we all are about processing times, and absolutely 4 years, that is not acceptable. But that all said, I don't know how much we can rush that process. You know, we can definitely demand efficiency and adjudication in accordance with the law, but what does that translate into? I mean, what is a reasonable output? You know, I don't know. I think we have a feel for what isn't, but what is? I don't know. It used to be 4 months, years and years, eons ago. It feels like that felt pretty good. 4 months felt like the money can stay in escrow and all of that. And it feels weirdly like we have some return of that, right? Because some of these petitions are getting lightning fast adjudications, it seems. So yeah, I don't know. I don't know if I've even touched on addressing that question. All right, let's move on and see where we go. Got more. Typically, it is expected that chart B date is set prior to 8 to 10 months chart A date. Yes. And for the reason that Suzanne just said, but we're seeing these artificial, or I don't know if that's a good word, but these huge jumps in chart B, which is hard to complain about, right? I mean, we can kind of question, does that make sense? But I don't want to complain.
Yeah,
right.
And it's also interesting because all of the past Visa Bulletins are just out there on the Visa Bulletin website. If you want to, which I've also done, you can make a little chart in Excel and look at the past and see in the past was 1 year's chart B date. Did that become the next year's chart A date? How close was it that to be accomplished?
What'd you find?
Well, I only did that for China EB-5. China EB-5 had a couple years that were close and a couple years that were not remotely close at all.
Wow.
But again, going back to the fact that the dates don't come out of nothing. They're a function of supply and demand. And so when we look at weird things that happened with the dates, we can think what weird things are happening on the supply or demand side. Like the fact that during COVID-19, all of a sudden it jumped way forward, and
right.
it was because of conditions that, number one, USCIS wasn't, their productivity went down, so people weren't reaching the visa stage. Another thing was that the consulates were just limited by COVID-19 to not issue visas, so they didn't need the additional traffic signal from the Visa Bulletin to tell them they couldn't issue visas. They weren't doing that anyway. And then during the regional center program shutdown, the dates also jumped way forward. And the reason for that is that the demand changed. All of a sudden, regional center investors couldn't get visas. The demand number was only the direct EB-5, which is a very small number. So when you've got small demand, big supply, the wait time
Can
goes
advance
down
more.
and the dumps could go forward. And then it had
So-
come back again. The dates had to come back again when the demand expanded by having all the regional center investors coming back online.
So it sounds like you're saying that, yes, it is rational. It is based on demand, and it's not these other sort of, because, we all sort of wonder, is what's going on in there, right? There's there's some theories, but based on your observations, you're saying that it is based on tabulation.
Well, it comes out of facts in the real world about supply and demand. Unfortunately, that doesn't make it too much easier to predict, though. I actually used to have a timing service that I offered to investors where I said, let me calculate the data and make a prediction for you. That was in 2019. I totally failed to predict that there would be a worldwide catastrophe that would shut down consulates around the entire world for a year and a half.
Suzanne, that's it.
I didn't even think about it.
Yeah. No
And then the fact that the
regional
regional center program could shut down entirely for 8 months. I didn't think about that either.
Yeah.
So unpredictable things happen, but still how the Visa Bulletin moves is based on something. It's based on demand, and that demand comes from somewhere that we know about, which is I-526 filings by country. Is based on supply, which has things we know about. We know there are at least 140,000 EB visas every year. We know how that gets sliced and diced. We know how the carryover works. So there are facts to look at.
All right, we're gonna just drill. I'm not editing questions. I'm just going because that's what we wanted to do. What's your opinion on filing for rural versus urban TEA for backlogged countries like India? Whew. Oh heavens.
Well, it's 20% is twice as good as 10%. On the other hand, both of them are kind of small numbers. But on the other hand, it's still early days, so maybe both percentages are fine.
And it's right. And it's, well, how many are ahead of me in the 20%, right? 20% is double the 10%. But whether or not it's advantageous to go in the 20% versus the 10% depends on how many are ahead of me. And
right. So another person mentioned that there's been a huge push for investors in rural projects. If that huge push was successful, and a large percentage of people who have filed already are in rural, that means, the high unemployment lane is sitting there looking nice and empty.
And some people are making those calculations. And I think that's what guesses is really what they are. And I think that is exactly why advocates like Suzanne and others are trying to get that transparency in those numbers. How many are there ahead? Even if it's just petitions and we've got to apply some sort of multiplier, that's the number that we do not have. And that's what you need to answer that question.
I have some hope that we're going to get it, because AIIA did sue on that, and their litigation results should be coming through shortly. Also with IIUSA and also AIA have spoken to the ombudsman, the CIS ombudsman, and high on our agenda was asking for this information, saying we need to know how this demand is distributed so investors can answer exactly these questions. In fact, maybe Carolyn, you should copy this chat and add it as an exhibit for the ombudsman.
Oh, I didn't have to. As I was drafting that question, I was thinking of all of the times in the consultations with clients, prospective clients. This is the question. This is it. And it is very, it's hard to not be able to answer this critical question. So hopefully it's out there. We've said this is really, really important. We need this to plan. People need this before they make this sizable investment of their time and resources. So I'm with you, Suzanne. I'm cautiously optimistic. I really am, because the information exists.
Yeah, right, exactly. They just need to tell us. Also, I put a link in the chat to the page on my blog where I put any processing data that I have. So
great.
You can always consult that, and whatever is the latest information I have about I-526E, post-RIA and pre-RIA, I'll always have there. All
right. So we are well past our hour, but we are going to keep going. There's a huge push from investors for rural projects versus employment. What are your projections as to which visas will likely be a better investment? I think this is it, right? I mean, in terms of timing, we don't have the answer.
Yeah, and then it's important to remember that the immigration calculation and the investment calculation both need to be made, and they have quite different considerations, independent considerations. So yeah.
Oh yeah, yeah. Post-RIA are high unemployment, and TEA classification is the same. Which agency will determine the area to qualify for high unemployment and TEA? Good question. Okay, so TEA, think about it as an umbrella concept, and it's all about what investments qualify for the lower investment threshold of 800,000 versus the 1.05 million. Okay, so it's an umbrella, and under the umbrella are the set-asides. We've got the rural, the 20%. It's a type of a TEA, and the high unemployment is a type of a TEA. Infrastructure is in the set-aside, but it's not technically a TEA. TEAs are rural and high unemployment only. And then you've got this set-aside category of infrastructure that gets 2% of the annual limit. I hope that's clear. What is the reason H2 high unemployment area 526 petitions approval rate is much lower than the rural set-aside?
If by approval rate they mean approved versus denied, I don't think we can say that yet. I don't have any data on denials. If you mean the volume of approvals, in theory, the volume should be higher for rural because in the law, they say rural is supposed to get priority processing, whereas they don't say anything like that for high unemployment.
Will the unused rural visa be consumed by backlogged countries in high unemployment, or will they roll roll over or go to an unreserved category? Okay, I think we can answer that.
So my understanding is that the categories are very siloed. If you're a rural if your approval is for EB-5 rural, you need to get an EB-5 rural visa. You can't get a high unemployment visa. If your approval is checked high unemployment, you can't get a rural visa, even if there are leftovers within that category.
This is a great question. I mean, we know that in the year one of the carryover, right, it is going to, those numbers are going to stay in the same category.
Yep, rural to rural.
Rural to rural. The question is, the second is what happens in the second year when those unused set-aside numbers roll up to the unreserved.
Right.
There is a question as to whether there is separation up there. I think yes. And then once there's separation between reserved and the unreserved, within the reserved, do they stay segregated along the categories of the set-asides? I think yes as well, but that's a question. Yeah,
I'm not sure what you
mean.
Well, once it becomes an unreserved visa, then it becomes available to people who are in the unreserved category in order of priority date, right? And
I don't know. I think
I think we can look at that know that from looking at our past set-aside categories, which we even forgot we had. But we used to have a regional center set-aside and a TEA set-aside, 3,000 each. And in those cases, because we had way more than 3,000 TEA and regional center investors, when those were used up, they could use the remaining 3,000 or so unreserved visas in priority date order. The thing is about today is that the unreserved visas, if they're just allocated in priority date order, there are 70,000 or so pre-RIA applicants in the system who are going to have the earliest priority by date for those visas.
I think this is a very important question, actually, about how that second carryover into the unreserves, how those numbers are going to be categorized and used. One of the main questions I have is, what if those numbers, let's assume that they're at least separated that way. reserved and unreserved. It's an assumption.
You mean within the reserved category?
Within the unreserved, within the unreserved, I am positing that there is a separation between the annual allocation or the annual unreserved pool of numbers in there, and the second year carryovers. I don't know whether they're mushed together or whether they remain separate. Let's assume that they remain separate. If they remain separate, and then it would make sense for, in my view, for the visa office to use the annual limit first. Because the unused numbers in the annual limit must fall up to EB-1. It has to. Whereas I believe that there is an argument to be made that the carryover from the reserved that is fallen up to unreserved in the second year, I think there's an argument that those numbers stay there. And so if they stay there, then, you know, we have other questions open up. You know, is it that 1Q, or is it something else? So anyway, stay tuned. Okay, so we got that. To clarify, did the guidance from USCIS provided today clearly state investment sustainment period is defined as at least 2 years from contributed capital and the filing of an I-526E? Ooh.
I would say
I don't think...
go and read it, because Carolyn hasn't had time to do her in-depth analysis, but I did put a link to exactly what they say at the top of the webinar chat.
Thank you. That is the answer. Can pre-RIA 526 pending cases apply for adjustment using Chart B? Yes. Oh, yes. Yes, yes, yes. Where to find number Indian in petitions are pending by December 2019 to estimate whether Chart A date can reach December 2019 by December 24 ends. Okay, so this is the sort of, you know. Okay.
I'll look for 2 links to give you. We don't have complete data. What we do have is the number of I-526 that were filed by month, which you can sort of calculate from that. The other thing, the most recent information we have on I-526 pending by date is of March 22. So I shall put those 2 links both in the chat.
That's wonderful. Yay. All right, well, we have reached the end of our posted questions. This was awesome. I feel good, you know? I think we did it. We did our best. We got some good information out there. So thank you, Suzanne, so much. We have to do this again. And do you have any parting thoughts for our audience today?
Oh, well, there is so
much. Oops. Oop. And you're frozen. Oh, darn. I don't know what happens when a guest freezes. Oh, there you go. Yes. You're back. You froze midstream there, Suzanne. So, yeah. Give us your...
Well, I was just going to say, I'm not even going to start on all of the things I didn't say, but I think this is very useful for what we were able to go over.
Indeed. Thank you so much. And thank you, folks, for joining. Our next webcast on this forum is sometime in October. Oh, I should know this date. It is in a couple of weeks. And we'll be covering regional center compliance to G or not to G, the I-956G form, the integrity fee announcement we were going to cover, and now we are going to cover the sustainment as well. So I think it's October 19th, but yeah, we'll send something out. Thank you so much. Bye, Suzanne. Have a wonderful rest of your day. Enjoy the day, everyone.
All right.
Read the new posting. Bye-bye.